And for his insights on our lawmaker SALNs, we have Paolo Tamase, Assistant Professor at the UP College of Law. Magandang umaga sa'yo. Welcome back to Morning Matters.
Good morning, Gretchen, and to everyone viewing your program.
Okay, over the past weeks, we've seen these releases of SALNs. May iba na kapani-paniwala naman, may iba na sabi nga ng publiko ay nakakataas ng kilay. What do you make of the declarations so far?
Well, SALNs are an important but an imperfect instrument. They're important because they're the actual sworn declaration of a public officer that this is his assets, liabilities, and net worth. But they're imperfect because there are many ways to evade SALN. Even in the past, in the 1990s and the 2000s, and the corruption allegations at the time. One of the principal allegations is that people often hide, or public officers hide, their wealth under dummies, or different names, or their associates. So hindi siya perfecto na instrument, but it's important precisely because of how the public reacts to them. So, for example, there's a SALN that shows that this public officer only has the certain amount of assets, but the lifestyle is so incongruent to those assets, then the public would start asking important questions. The media would be triggered by those questions. And then you have the important conversations around whether that public officer is declaring his assets faithfully, and if not, why not?
So it's exactly this reaction from the public that we want to elicit. No? But in terms of legal liabilities and cases that can be filed, pwede naman kumuha dito sa mga public declaration. Kumbaga parang side by side na yan. For example lang, kasi kay Senator Chis Escudero, nagulat ang lahat na siya yung poorest senator when yung kanyang iniregalo kay Heart Evangelista more than yung kanyang SALN. So, pwede na ba yung tignan at busisiin at pwede na ba mag-build ng case from there?
Well, yes. False declaration in a SALN is itself punishable. It's perjury. It's lying under oath. And while, of course, anyone who files a case against, just using your example, Senator Escudero would have to indeed prove that there was lying in the SALN, then that would require evidence to show the discrepancy between what he actually owns at the given time, that he declared his assets, liability, and net worth, and what was declared in the SALN. So that can already start a case as long as there's proof. It's one thing to have allegations concerning these misdeeds. It's another to find good proof that will survive the scrutiny, let's say before the Ombudsman if it's an administrative case, or before the courts if it's a criminal case. So pwedeng yun yung the starting point basically.
But some people actually belittle the value of SALNs because many of the line items there's a perception that they're heavily undervalued. For example, yung mga presyo ng properties, parang pag tinignan mo, para alam mo na sobrang mahal yan sa market value, pero pag tinignan mo sa papel, biglang ganyan na palang kaliit. And I guess I wonder if it's because of the real property taxes. Diba? Usually, mas mababa talaga yung rate niyan kasi you go to the local government to ask to assess value. Yeah. Paano yung ganon? At pangalawa, if entries are undervalued, what could happen? Could that fall under false declaration?
Well, to begin with the second question, yes. If entries are undervalued, then they fall under making that false declaration, that perjurious statement. But whether the amount is correctly reflected, people also have to look closer into the SALN. So assets are generally required to be declared both for their assessed value, which would correspond also to their market value, and their acquisition cost. How much was that asset purchased? So it's possible that over time, mag-iiba talaga yung presyo ng asset. It will go up, shoot up. But if you purchased property 20, 30 years ago, then yung acquisition cost niya would also be very little. So yung bottom line figures, the amount, the numbers that are reported in the media, I think that's of secondary importance. The most important is actually the asset itself, di ba? If it says that this property is in an exclusive subdivision, then that would be that would trigger, for example, questions about why sobrang undervalued no property. And I think just to inform the public, the SALN itself, which they see reported on media, has a lot of information redacted. And rightfully so, I think. No? Addresses of these public officers, pwede naman talagang mag-claim ng some balance of privacy in their favor. But the copies that would have been submitted with the Ombudsman, those are not redacted. And I think, it would be within the purview of a proper request, let's say by media, by watchdogs, to request the full information about what the SALN provides. When public officers accept public office, they accept that certain privacy rights are given away in the interest of accountability and public scrutiny. So, dapat tignan actually yung asset, hindi yung value only.
What's the rule on those who are married, no? Kasi for example, Senator Escudero can claim that he has a prenuptial agreement with Heart Evangelista. Paano yun? Pagka may prenup pa, hindi na kailangan isama yung wealth ni Mrs. Or does that exempt him from disclosing that? Paano?
Yeah,
How does that work?
Two brief points. The first is under the law, under RA 6713, spouses are required to actually declare their wealth as well. So public officers and their spouses, as well as any children below 18 living in their households. But there's a civil service guidance, memorandum circular in 2021, which says that if the spouse owns exclusive property, then that can be omitted from the declaration, from the SALN declaration. An exclusive property can mean many things in law. One of them is, for example, if there's a prenuptial agreement. So I can understand the argument na pag may prenup, if that prenup provides that husband and wife own their property separately, no, they don't own it as a conjugal property or as a community, then pwede siya i-omit sa SALN technically. That's the first point, right? But on a second level, there is nothing that stops a public officer from actually declaring including the wealth of his or her spouse. And part of that goes to why we require SALNs. SALNs are a measure of public transparency by public officers. So if they want to ensure that walang questions about their integrity or their wealth or questions about the lifestyles that they live, it actually makes sense to include the declaration of the spouse. Include nyo na yung properties ng spouse. Anyway, if naka-declare yung property ng spouse, it doesn't make the SALN necessarily false because you'll say in the SALN that it includes the property of your spouse. So that type of transparency calls not anymore to whether a public officer is complying with the law. It's whether the public officer understands yung obligation niya to be transparent to his own constituents.
Well, apart from Senator Escudero, si Raffy Tulfo at ang kanyang misis na si Jocelyn, na nag-declare sila joint SALN. But there's also, for example, Alan Peter Cayetano and Lani Cayetano na hindi pa nagde-declare. How about the market value of inherited property? Shouldn't that be included in the computation?
If the property was inherited by the public officer, then yes, definitely it should be included. SALNs are a snapshot of how much a public officer owns at any given time, regardless of where he got or she got his wealth and assets. If the inherited property, however, was inherited by the spouse, then that would be properly excluded from the SALN. So, halimbawa, the spouse comes into this inherited property under civil law that would normally be excluded from the property of the of her husband, the public officer. So hindi yung kailangan isama sa SALN. But again, it's one thing to comply with the law. It's a different thing to comply with the expectations of the public about the transparency of their leaders.
If you want to make a stand na wala kang tinatago talaga, no? But speaking of, no, two institutions the public is still waiting for the declaration of SALNs, while may nauna na sa House of Representatives, marami pa ang hindi pa nag-release ang kanilang mga SALN. And another is the Supreme Court. Is there any legal way or remedy for the public to demand these institutions to be able to declare their SALNs?
Well, going to the Supreme Court has an issuance which regulates the release of SALNs of members of the Supreme Court. Part of this arises from the 2000s cases, no, that were filed against Chief Justice Corona, then later Chief Justice Sereno, concerning or that were based on their SALNs and their either failure to declare or misdeclaration. So, the Supreme Court, you can understand why over time that they have become very guarded against the release of their SALNs. But respectfully, I think and there's a process that you need to go through, no, in the Supreme Court in order to get their SALN. So you file a proper request. That request is evaluated by the court. But with all due respect, one of the more ancient questions we have in public law is quis custodies, ipsos custodes. So, who guards the guardians? Who watches the watchmen? And
So,
I
sino
think
nga ba?
if the Supreme Court is an unelected body, it is only subject to impeachment, and impeachment has been made very difficult by the own rules of the Supreme Court now. Then it might actually serve public transparency and accountability for the court itself to voluntarily declare its SALNs or release its SALNs. It's within the power of the court. So if the court wants to take seriously or wants the public to take seriously its commitment that it will champion accountability in government, it can begin with the court itself. It's a good example also for the lower court judges to make a similar declaration. No? Gretchen, all public officers declare SALNs. I'm a tenure track faculty in UP. I declare my SALNs. And I think, for it's a good signal for our highest officials to also do that, to show now everyone is accountable in government.
Of course, that's the ideal situation. Most of the time, they don't want to police themselves or somehow lead to their own demise. Pero I want to go to the announcement of the Ombudsman, the current Ombudsman, yesterday, that they are releasing the decision of the former Ombudsman on the reversal of the dismissal order of Senator Joel Villanueva relating to the PDAF. Unang-una, bakit nagkaroon ng ganyan na parang may secret decision? Lahat ba ng dapat na desisyon na ombudsman isinasa publiko? Why are we having this whole debate about what's made public and what's not?
Right. I think so. If you look at the law, there really is nothing that requires the ombudsman, diba, to publish his decisions and his reversal of his decisions. But I think what advocates have been saying, what the academics have been saying, is that just because the law doesn't require doesn't mean that the ombudsman isn't bound by tenets of accountability. Part of the reason why the last ombudsman in particular did not release these decisions, I think, and based also on his previous statements, is that you also want to protect the dignity of the public officer, so to speak. Na hindi naman siya parang publicly tried. But with all due respect, public officers, especially high public officers, take that as a risk when they accept public office, whether if they run for it or they accept an appointment, a high appointment. So if we are to be faithful,
go ahead.
Yeah, go ahead. Sorry. If we are to be faithful to the ombudsman, to the ombudsman's role as a watchman of the people, na tanod bayan, then it actually helps to declare these or to post all of the decisions and resolutions of the ombudsman. It's a good step, and it furthers public trust in that very important office.
That was actually one of the things that was baffling about the statement of the former ombudsman na hindi naman daw secret decision, but it's supposedly to protect his dignity which is parang dapat mas lalo pa niyang nirelease yung dismissal order na yun, no? Kasi hindi ba dahil doon niya sinabi that there was no adequate evidence on record that Senator Joel Villanueva was actually involved in the embezzlement of 9.7 million in his PDAF. So parang it ran contrary to the decision, hindi ba?
Yeah, and if you look at, and we're starting to find out more information from this case, just with that single disclosure of the ombudsman. We know now that there were actually two cases filed. One was an administrative case, one was a criminal case. No? But the content of the reversal itself said na walang forgery according to the ombudsman's more recent findings. So it actually helps the public officer to be exonerated in that way. Kaya hindi din, for me, it's very hard to reconcile the ombudsman's function with the exoneration of Senator Villanueva and the conduct of hiding the decision from the public. Maybe it's para hindi na pag-usapan, no? But sometimes these public conversations actually help public officers, especially those who perform their job well, no? And who have a commitment to public service.
Going to that 2019 dismissal or reversal of the dismissal order, Ombudsman Samuel Martinez said there was cogent basis to grant the motion for reconsideration filed by Villanueva, contesting the earlier findings by former Ombudsman Conchita Carpio Morales. Ano ibig sabihin nun? Pwede ba yun na sabihin lang niya na the signature was forged?
Well, technically, he can. The grounds for a motion for reconsideration, I think even before the ombudsman, would often be errors of fact and errors of law. So, if in the opinion of the graft investigator, the original decision, which found liability for Senator Villanueva, was premised on a misappreciation of the evidence that was presented before the ombudsman initially, then it's within the power of the ombudsman to reverse it. And that's okay, right? I mean, just because a public officer is accused or is charged with a graft offense doesn't mean that that offense is necessarily true. It's possible that the officer has defenses. It's possible that he has evidence that the public hasn't seen or that the media hasn't reported. And the system precisely exists to allow that public officer to clear his or her name. So that's entirely possible. Pero yun nga, no, if that reversal actually results in clearing the public officer, why not disclose? Why not share it with everyone? It also is a good guide for the media in the future, for the public in the future to consider what would be, the possible reasons why the initial report might not be correct, if it were indeed not correct.
Of course, these are decisions back in 2016 and 2019, and we're now in 2025. One would wonder, why is this issue being brought up? Is it possible for the current ombudsman to reverse the reversal of the dismissal order? Kumbaga, baliktarin itong lahat, buklatin muli, at i-pursue yung kaso to see if to see if there's merit in that finding that the signature was forged. Posible ba yon? And at what point does it become double jeopardy?
Okay. With the caveat now that I haven't seen the full record, I only have the decisions of orders of the ombudsman reversing the 2016 decision. You have to look at the two reversals separately. On the administrative case, I think there's a case to be made that because we have this principle of administrative res judicata, tapos na yung issue na yon on the administrative side, right? The period has lapsed, the time has lapsed, and therefore if the ombudsman found finally na Senator Villanueva is innocent of the charges against him, then the ombudsman can't reopen that side of the case anymore, yung on the administrative liability side. But the criminal side is different. Criminal cases, after they are investigated, they don't go through or they are not subject to that rule of administrative res judicata. And what the applicable rule is double jeopardy. Now, on that part, double jeopardy only bites or only kicks in when the case is already with the court. And because the dismissal here was in the stage of the ombudsman, at the preliminary investigation stage, wala pa siya sa court, hindi pa siya umakyat sa Sandigan Bayan.
So pwede pa.
So technically, it is within the power of the ombudsman to reopen that case and see, was there a misappreciation of the evidence that were brought by the parties? Are there new evidence that would actually point to criminal liability? But as a larger comment on how these things go, no, when an investigator reopens a criminal prosecution, one that hasn't been filed with the court yet, it requires a certain amount of evidence per experience na meron ba talagang evidence na bago or meron ba talagang serious misreading? Were there allegations of misdeeds in the initial investigation of the ombudsman or the investigation during the reversal? So, kailangan ma-justify yun by that. Otherwise, the ombudsman would be using its resources to open a case that would not be viable anyway. So it requires also some judgment and discretion on the part of the current ombudsman.
Speaking of signature forging, no, there's another one that's in the spotlight, which is the Senate witness Orly Gutesa. Sinabi ng Manila RTC that they found the notarial signature was forged. What's the effect of that on his testimony? Does that render it null and void?
Well, on the testimony in written form, the one in the affidavit that I think was presented to the Senate, if the notarial signature was forged, then it means that that statement would not hold up, right? It's not a sworn statement anymore. Because the notarial signature is apparently fake. It also will raise very important questions about how that signature was fake, no? and who procured
And
the
why?
fake signature. So who was responsible for the affidavit? But anything that he said in the actual hearing in the Senate is still under oath. And therefore, regardless of what was said in the written statement, what he said in the Senate itself, yung sinabi niya talaga, outside of those written statements, would be acceptable as testimony. And if he lied under oath for that, he could also be charged with perjury.
Super final question before we let you go. Speaking of statements made in these hearings, marami na po sa taong bayan ang naiinip ngayon dahil nga there has been no case or not a single charge has been filed against anyone involved in the flood control scandal. Yung mga testimonies dito sa hearings, can they already pass off as, I guess, affidavits? And can they pass off to build the cases? Kasi sabi ng DOJ that they want this airtight, they want certainty of conviction before it files anything. So what's your take on that and the speed of how things are going?
So we need to find a balance between immediate relief, no, to the public anger, which is addressed by speed, and winning these cases. We had just seen an acquittal of a pork barrel case and many acquittals before that, based on lack of evidence or insufficient evidence. And I'm not saying that evidence was really insufficient. I haven't seen the record. I wouldn't be able to make that assessment. But it's a warning sign that we need to be able to translate public anger to actual convictions. That includes working on airtight cases as well as speedy presentations of those cases. It's possible kasi that the case was airtight, but over time it degrades if the case isn't prosecuted quickly. Yeah, so we need to find that balance. And I think statements in the Senate are important evidence, but the real evidence of graft is not what is said. It's in the accounts, diba? It's in the ghost projects, it's in audit findings. Those things are not often said or will not have been said in the Senate. They would be done by independent fact-finding. So the Senate testimonies are a good tip, essentially, for our graft investigators. So people need to be patient, but they also need to persevere.
But
it's good for us.
What's the lowest hanging fruit that they can go for to relieve public anger?
So I think the ombudsman is now going after a few cases. So there was a press release, I think yesterday, that they would file certain cases by November 25. And that means that they're basically just putting together the case already in a airtight form, no? And to litigate that. But if my understanding of the press release is correct, it would be filed with the regional trial courts, which means one thing or two things. So one is that the amounts might not be that big, and second is the officials might not be that important yet, or that hindi pa sila yung big fish. And I think the low-hanging fruit is often the smaller, lower-ranked officials who participate in the graft. And I think that's important to go after. No, anyone who has participated in these schemes should be held accountable. But we also need to focus on the really big fish. Kasi ang complaint nga usually with the way that our graft system works is ang dali manghuli nung small fish. Ang hirap hulihin nung masterminds. And if we're really serious about accountability, it's the masterminds you should be going after. So it's a good thing to parang throw to the public now. Okay, look, we're doing this, we're working on this, we're looking for the bigger fish, but it can't stop with the initial cases that are being filed. And as I understand it, just based on what's happening or what's being reported, mukhang hindi naman ganun yung case. Right? So it looks like the officials are serious about it.
Okay. Maraming salamat for helping us understand so many of the legal matters here between different issues. And we'll let you go. No, it is October 31, Halloween and pre-All Saints Day. Thank you so much for your time today. We have Paolo Tamase, Assistant Professor at the UP College of Law.
Thank you, Gretchen.